Welcome to today's podcast. My name is Pearlie Brewer, and I will be your host. Today's podcast guest is Kelly VanBuskirk. Kelly is a lawyer for the Lawson Creamer law firm and specializes in labor and employment law, civil litigation, administrative law, and business immigration. Kelly is here today to talk to us about Bill C-45 in general and specifically about the Springhill Construction case. Welcome, Kelly.
Hey, thanks, Pearlie. Good to talk to you.
First, why don't we get started by getting you to tell us a little bit about yourself, how you ended up in the law profession, and what's kept you busy over the years?
Sure. Well, I decided when I was in grade 8 that I would like to be a lawyer, and I kept that a secret until I made sure I could get admitted into law school, and was fortunate to attend the UNB Law School, where I graduated in 1992. Since then, I've been practicing primarily in the fields of labor, employment, and human rights law, representing employees, employers, unions, and in some cases, the tribunals that make decisions in these cases. And I've had the opportunity to serve as an arbitrator under the Occupational Health and Safety Act here in New Brunswick as well. So that's what I've been up to over the last 3 decades.
So let's get right to our topic then. Bill C-45.
Yes.
For folks that may not be familiar with Bill C-45, what is it? When did it become law? And what does it say specifically about management and supervisor safety responsibilities in the workplace?
Sure. Great question. And Bill C-45 really came out of the Westray mine disaster in Nova Scotia. And it was in the aftermath of that tragedy in 1992 where 26 miners were killed in a mine accident. The government decided that it would be appropriate to really strengthen the legislation that obligates employers to take safe measures for the benefit of their employees. And so Bill C-45 was the document that led to Section 217.1 of the Criminal Code of Canada. And that became law in 2004. And what that Section 217.1 does is it creates criminal liability for employers who don't take all reasonable steps to ensure the safety of their workers.
Now, what are the penalties associated with this piece of legislation if either a supervisor or an employer does not comply?
Yeah, the penalties are substantial. They can range really from relatively small fines, anywhere from $2,000 fine all the way to no limit on fines or imprisonment. And here in New Brunswick, we've recently had the case of Jason King, who was a supervisor convicted under Section 217.1 and who has been assessed a 3-year period of incarceration or jail time.
Now, from what I've been able to read, there hasn't been a whole lot of cases across Canada with Bill C-45.
That's true. Yeah, not that many. There have been a couple. Metron Construction is sort of the bellwether that is often referenced in Toronto, but Rainbow Concrete, there's a Detour Gold case, and a few others really across the country that have tested Bill C-45 or section, 217.1 of the criminal code. In the Metron case, the company and 3 officers of the company were fined $200,000 as a consequence of their non-compliance with the legislation. But to your point, Pearlie, it's not been a heavily utilized provision of the code.
Why do you think that is?
Well, I think, really good question. I think that first, it overlaps the occupational health and safety legislation that exists in each jurisdiction across the country. So I'm confident that your listeners are aware of that occupational health and safety legislation, which regardless of, where a company is operating in the country, they are subjected to and subject to that legislation, which requires them to take all reasonable precautions for the benefit of the safety of their employees. And that provincial legislation, the OHS legislation, creates its own set of penalties and remedies for violations, safety violations. My guess is that in some instances, at least, there is a decision made to proceed under the provincial legislation and not the criminal legislation. I also think, just being blunt, that there has been concern about the idea that criminal liability would extend into this realm. And so I think there has been a little bit of hesitation in terms of applying Section 217.1.
So, in the Springhill Construction case, Michael Henderson died tragically on August the 16th, 2018, while working for Springhill Construction at the Fredericton Wastewater Treatment Plant. Initially, WorkSafe NB, because it is a workplace accident, responded to the scene and started an investigation looking into what caused the accident. During the investigation, they determined there might be potential for charges under Bill C-45. The employer, the City of Fredericton, had hired Springhill Construction as a contractor for the project. Springhill was also the employer of the supervisor, Jason King, and the employee, Michael Henderson. Now, over the last 2 years, as I did supervisor responsibility workshops around the province, I was asked a number of questions about this particular case. What I'd like to do now is put some of those questions to you to provide your perspective on how you would go about to answer them. The first question that I was often asked was this. In New Brunswick, since the NBOH&S Act was introduced, employers have recognized their responsibility for contractors carrying out work on their work site. For example, the City of Moncton hires extra safety staff each summer to visit the various project sites to ensure that they are in compliance with legislation. NB Power, when doing shutdowns and upgrades at Point and Pro, trains supervisors to oversee each contractor on site. Employers like the Irvings and Moosehead breweries closely monitor contractors on site, and if they are not in compliance, they are ushered off site very quickly. Given this, and despite the recent court ruling involving the City of Sudbury that reaffirms the municipalities are responsible for the work site, the City of Fredericton was never charged either under provincial health and safety legislation or Bill C-45. So a question people often ask me, so why were there no charges for the City of Fredericton, especially given the testimony that came out during the supervisor's trial? Why would they not have been charged? What's your take on that?
Yeah, that's a tough one. I think that, here often, as you know, Pearlie, in these circumstances where, there's a construction site and a contractor hired, often subcontractors are hired. There are a number of different ways that I suppose the owner's obligations can be discharged. The owner's safety obligations can be met in a few different ways. and one of those ways is to specify the manner in which the work is going to be done. And if that specification is such that it really transmits the responsibility for the safety requirements to the contractor, then the argument is that the owner, in this case the city of Fredericton, has discharged its duty. In the decision on the Jason King charge, the supervisor's charge, at paragraph 148 of the decision, the court noted that the city had made it a specific requirement that a leak test was to be completed by the contractor. And there had been no specific plan for that leak test signed off by the city. And I think that's one of the complications here, is that the city had made clear that a leak test in this tank would have to be completed. The contractor did not come back to verify with the city how exactly that leak test would be conducted. And so the finding of the court was that the witnesses who testified in the trial were unanimous that it was unsafe for the contractor to have conducted this leak test, which involved, an inflated plug in a hole. It was unsafe to do that test while there was an actual person, in this case Mr. Henderson, in the hole. I think that the contractor made that decision. The contractor knew that the city required a leak test, but didn't seem to involve the city in the plan for the conduct of that leak test. I think that's a potential explanation for why the city wasn't charged.
Now, to go back to a comment you made about the way contracts are written up relative to the employer-contractor relationship. One of the things I was taught way back was that under the sort of concept of due diligence, that you can delegate authority to another party to carry out work, but you cannot delegate your legal responsibilities. I.e., the city of Fredericton could say to a contractor, yes, we're going to delegate to you a project, and we expect you to carry it out, but you cannot delegate your legal responsibility for safety on that site. What's your comment on that? Am I correct on that or not?
Well, I think that that's arguably the case. I think that, however, if you're not conducting the work, and if in fact someone else is contractually obligated to conduct the work and to conduct it in a safe manner, then the argument becomes that the individual or the organization that is contractually responsible for doing the work is, bears prime responsibility for the safety. And you can appreciate why that might be. Many of your listeners would be in a circumstance where perhaps, they've been involved in hiring a contractor to do work either in their home or, let's say in a business setting. They hire a contractor who they understand to be experts not only in the conduct of the contracted work, but in all aspects of that work, which includes the safe conduct of the work itself. Put yourself in the situation of a homeowner who has someone working on a roof, say, replacing shingles. That homeowner might be responsible for a safety violation if the homeowner knows that the roofer is doing the work in an unsafe manner. But if there's been a commitment made, that a contractual commitment that the work will be done safely, and the homeowner doesn't know any difference, and ought not to have known any difference by reasonable observation, then it becomes more difficult to see a path to charge or to successfully charge the homeowner for the safety violation.
So what is the responsibility then of the employer in the workplace setting, not the sort of the personal setting, but the workplace setting?
Yeah, and I use that analogy just to sort of help qualify this responsibility. Under Section 9 of the Occupational Health and Safety Act, it is stated that every employer shall take every reasonable precaution to ensure the health and safety of his employees, also to comply with the Occupational Health and Safety Act and the regulations that fall under the Act. And as you know, Pearlie, the regulations are not insignificant. Regulation 91-191, which is the general regulation, factored heavily into the Jason King case. Finally, it is the responsibility of the employer to ensure that their employees comply with the Act, the regulations, and any order made in accordance with the Act or the regulations. And so that's a really broad responsibility under the Occupational Health and Safety Act, and the responsibility under the Criminal Code is similar. It says everyone who undertakes or has the authority to direct how another person does work or performs a task is under a legal duty to take reasonable steps to prevent bodily harm to that person or any other person arising from that work or task. It goes on in Section 219 of the code to say everyone is criminally negligent who, in doing anything or in omitting to do anything that it is his duty to do, shows wanton or reckless disregard for the lives or safety of other persons. And so, that is, those are the broad provisions that extend to employers and that require employers to take a very careful approach to all of these different safety issues.
Now, there was a recent court case involving the city of Sudbury, Ontario.
Yep.
And contractors. Do you want to sort of summarize what came out of that case?
With the city of Sudbury, this is the Ontario Court of Appeal case. It was decided in 2021. And in that case, the Ontario Court of Appeal ruled that the city was an employer within the definition of the Occupational Health and Safety Act in respect of a project that was being conducted for the city. The Supreme Court of Canada granted leave to appeal that Ontario Court of Appeal decision, and in 2023, the Supreme Court of Canada dismissed the appeal of the city of Sudbury. And so essentially what was considered in that case was the degree of control that is relevant to an analysis of whether or not an owner should be considered as the employer in the context of a construction project. And this goes back to the comments that you and I were discussing a little earlier, Pearlie, in the sense that when we talk about the exercise of control, what's relevant about that is the determination of the extent to which an owner of a project should be considered as the employer. And I think that goes to the point that when you look at what the Supreme Court of Canada said in the Sudbury case, it said that basically in contracting with a party that becomes a designated constructor, the owner creates a contractual relationship with that constructor which transfers responsibility to a constructor with relevant expertise. And what comes from that is that there can be circumstances where the owner surrenders control of the project to another party. And that other party then assumes responsibility for overall health and safety. It becomes a factual issue that contractors, but also owners of projects like the City of Fredericton in the Springhill case should be, very aware of and very cognizant of and careful about, because those factual matrices will determine whether or not the owner is considered to be the employer.
Okay. Now, why was a decision made that once, I guess, they get into the investigation, why was the decision made to turn the case over to the Fredericton City Police when potentially the City of Fredericton was involved in this case, possibly as an employer, as we've just talked about? Would that not be seen as a conflict of interest? Why did they turn it over to the Fredericton City Police rather than, say, turn it over to the RCMP? We often see that being done in other cases.
Right. So, the de facto answer is that, in my view, the City of Fredericton Police had jurisdiction. Now, the City of Fredericton Police Force could make a determination that, that it would have some apprehension of bias or incapability of fairly investigating the matter, the potential charge against the City of Fredericton. The City of Fredericton Police Force would have its own independence from the City of Fredericton. That's not to say that independence satisfies the general public, and it's not to say that perhaps an investigation by the RCMP or some other police force ought to have been considered. But in the case, it strikes me that on a preliminary basis, at least, the City of Fredericton was the appropriate police force to consult.
Now, in the case of the supervisor who was charged under Bill C-45, found guilty and sentenced to 3 years in prison, evidence at the trial indicated that the judge ruled that the Mr. King did nowhere close to what was minimally required of him. Mr. King's actions were a significant contributing factor. Now, one of the things when I went over the material again yesterday, in the judge's ruling, he talked about the aggravating factor in sentencing was the previous conviction of Mr. King. Now, quite often when we, through the media, we hear about court cases and certain evidence not being allowed in that would taint the decision from a point of view of somebody's past.
Right.
Why, I guess curiosity, why would that come into and be a factor here then?
Well, if you look at the way the Court of King's Bench decided the case of Jason King, it first made a decision on the conviction and then followed it by a determination on sentence or penalty for the conviction. In the first decision, the decision regarding criminal liability, you don't see reference to Jason King's prior criminal conviction, and that reference becomes more prominent, as you point out, in the decision on penalty. It becomes relevant on penalty because there is this question of repeat offense and whether or not somebody is generally demonstrating respect for the law or is perhaps reckless in terms of adherence to the law. And so I think that is an aggravating factor when it comes to the penalty, but it's not a relevant factor, in my view at least, when it comes to the determination of liability in the first place. And so, it is, I suppose, problematic because Mr. King's previous conviction really didn't have direct relevance to the conviction under Section 217.1, but on broad terms, I suppose it is some indication of, a repeated failure to comply with the law.
Now, in the case of the employer, contractor Springhill Construction, they were originally, according to what was reported in the media, they were charged under Bill C-45, and they were to go to trial after the supervisor's trial. So they were to go to trial in January of 2024. Yep. Now, given especially all the testimony that came out during the supervisor's trial about all the things that weren't in place, that should have been in place, why were they allowed to plea down from a serious Bill C-45 criminal negligence causing death charge under Bill C-45 to a much lesser provincial charge? That seems like quite a leap. I know pleas deals happen all the time, but that seems like a really big gap. Why would they be allowed to plea down from a serious, criminal negligence to a provincial, not saying to take away anything from a provincial charge, but it's certainly much less serious?
Right. In my mind, I'll just go back to a discussion you and I had a few minutes ago, in the sense that the overlap between the criminal code and the occupational health and safety legislation still creates some questions for Crown prosecutors, for companies, for the court. And that overlap, has this sort of, I suppose it creates some gray area, between the Occupational Health and Safety Act and the Criminal Code. My sense is that, first, the evidentiary standard, and secondly, the legislative standard under the Occupational Health and Safety Act is lower. I think it's easier to obtain a conviction under the Occupational Health and Safety Act than under the Criminal Code of Canada. So that is an attractive issue for Crown prosecutors to consider. I think secondly, if you look at the way that someone would be penalized under the Criminal Code of Canada, specifically an organization or a company would be penalized under the Criminal Code of Canada, it's likely going to involve a fine, some payment of money. And that's also what is considered under the Occupational Health and Safety Act. So therefore, I think the law generally is going to find some attraction to taking the safest route to get an outcome, which the outcome has to be one that involves deterrence, to make sure that other companies recognize the need to comply with the broad safety requirements that appear both in the Occupational Health and Safety Act and the Criminal Code. And I think that's what was being sought after in this case with Springhill.
Now, from a point of view of a plea deal, some people would suggest that, look, it's an easy out. I've had people say to me, well, look, with all the testimony that came out during the trial, as the judge ruled against the supervisor, there was practically nothing there, as to what should have been in place. And I guess some people are going to ask, did the prosecutor here take really too much of an easy way out here to plead this down? I know plea deals happen. I mean, that's a reality of the court system. But did they? I mean, that seems like such a leap to go from a criminal code charge to a provincial charge. And I guess some people are saying did they just simply take a too easy a way out? Now, the other factor that comes into play here too is we all know that there's a shortage of ground prosecutors in our province, as it is across Canada. And they're under tremendous pressure to, deal with a great number of cases, don't have a lot of time, don't have necessarily the resources. So would that have been a factor as well?
It could be, but I don't get that sense. And the reason I don't is because I think in this case, and if we can focus on the victim in this case, Michael Henderson, looking at it as a whole, what we can all take some comfort in is that there was a robust, active, thorough trial under the criminal code, which is the highest standard with respect to Jason King, and a significant, some would say, shocking penalty, at least in the context of the history of occupational health and safety legislation in Canada. So in my view, the prosecution services in New Brunswick advanced this case in an appropriate and appropriately aggressive way. When it came to the plea arrangement with respect to Springhill Construction, I think that what courts have to consider are the general sentencing principles, which include, as I mentioned previously, deterrence. We all have to recognize that deterrence is going to be somewhat subjective in nature and somewhat objective. We're all interested to make sure that companies are acutely aware of these safety responsibilities and that they implement those responsibilities appropriately. We also know that there's the risk that, human error is going to occur. In some cases, the human error is quite obvious, or at least obvious in retrospect. That seems to be the way it is in this case. But then our attention has to turn to how can we try to ensure that this won't occur in the future. In my mind, at least, taken in its totality, I think that the overall outcome in this really tragic case is such that anyone working in the construction industry in New Brunswick or across the country would have to gulp hard and understand acutely that there are significant, serious, devastating, and appropriate potential outcomes for failing to comply with safety legislation. And I think that's what, as a society, we have to strive for. I think that's what was achieved.
What would you say to a group of supervisors who say, and they look at the outcome of this case in general and say, why would I want to be a supervisor? Employee died. Supervisor spent 3 years in jail.
Yeah.
And the company, they pay $100,000 fine, but I mean, there are certainly much, much larger fines have been given across Canada. And the intent of Bill C-45 was to make organizations more responsible. Groups of supervisors that I've dealt with in the past have generally said, look, it's same thing over and over again. If, the employer can hire better lawyers, they will tend to get a much lesser sentence. And yet it's us poor supervisors that we continue to pay the heavy price. How would you answer that question?
Well, I wouldn't disagree that anyone who is supervising employees, especially in, higher safety risk environments, I think there are, parenthetically, I would say there are more and more high safety risk environments today than perhaps in the past, but certainly in traditional high risk environments like construction or natural resources, is it worthwhile to be a supervisor? you can make the argument that it's not. And you can certainly make that argument, I think, Pearlie, when you look at the very live, real risks that these supervisors face. When I think about the fact that, they could have a bad day and be otherwise very good supervisors and still find themselves in the crosshairs of a criminal investigation and potential conviction, which would include possible incarceration. That's a really heavy, responsibility for them to carry. At the same time, I think that's in part where our society is. We do impose very heavy responsibilities on so many people who have the ability to direct or to provide service to others, like supervisors. And I'm not answering your question articulately enough, but if it were me, I would have to agree. Anyone who aspires to be a supervisor, especially in construction environments, would have to think carefully about it.
So going back to our original topic of discussion in General Bill C-45, if you're a family member and you lost someone in the West Ray mining disaster and you're reading about this decision, and are you maybe sitting there thinking, Bill C-45, what it was intended to do, here we are quite a number of years later, is it really working the way folks had hoped it would work? Is it really sending a message to organizations?
I think if I had lost a loved one in the West Ray mine disaster, I would obviously have to come to grips with the fact that loss is permanent and I can't make it right. What I can do though is support efforts to ensure that those things don't happen again. Some kind of tragedy of that nature doesn't happen again. And I think I would look at the evolution of the legislation through the lens that efforts are being made to improve safety for all workers across Canada. I think I would have to, or I hope I would come to the conclusion that Section 217.1 of the Criminal Code is a heavy hammer. And that heavy hammer has been demonstrated in the Jason King case here in New Brunswick just this year. Would I hope that heavy hammer would fall on more employers, more companies? I think I would. I think I would hope that it would fall on more companies and fall more heavily on more companies than has been the case so far. And I think what all of us can do is continue to support efforts to, advance the legislation so that it can be used to its fullest extent. In some instances, we all have to wait for the best case. I hate to say the best case, but the most appropriate case to come forward where it will be crystal clear that a criminal conviction against a company is appropriate and that the penalty should be appropriately significant. Let's not forget, Pearlie, that in some cases that has been true. If you look at what happened in, let's say, Metron Construction, it seems to me that there was incarceration for one of the supervisors in that case as well. There were some really significant fines issued against the company in that case. Can we expect that some CEOs of companies will be made subject to criminal liability and incarceration. That's happened in some other countries, not here yet, but that's probably on the books.
Now, one last question here. You mentioned the perfect case. I've had a number of people say to me and say it to me at workshops when they went over all the testimony and so on. And they said to me, look, this seems to be the perfect case for Bill C-45. And after the supervisor's trial, they said, yes, that's more or less what we would have expected.
Yeah.
Yet it seemed to fall apart when the plea deal was made.
Yeah. Yeah, I struggle a little bit because in the Jason King case, there are a number of references to what seem to be substandard training and supervision of King himself. And of course, that would fall on the shoulders of Springhill. We don't know necessarily all of the evidentiary dots that would have to be connected or that exist and would have to be connected in this case in order to create an ironclad conviction. We don't know that because, as you know, Pearlie, what happens in these cases is that the Crown collects the evidence. The Crown has its theory of the case and the evidence to support that theory. The defense has its own theory of the case and has other evidence to contradict, the Crown's evidence. What has to happen then is a weighing of the evidence in a way that will manage the risk of going to trial and not getting the outcome that the Crown wants to get. So sometimes it's a case of making sure that you leave the trial with as much of an outcome as is possible in light of the evidence that either exists or doesn't exist in the way that you want it to. So hindsight is always 20/20, but my thinking is that here we can take comfort in the fact that the prosecution services did approach this in what I would consider to be a reasonably assertive way. I'm assuming that somewhere in the assessment of the evidence, it was decided that there was some reason to accept this plea deal.
I hear what you're saying, and I understand very much what you're saying. I guess the part I find hard was after the first trial, when all the evidence came out and it's on the record.
Yep.
I would think that has to weigh pretty heavily on the second trial, in this case to the employer. Is that not the case?
Well, I would say potentially, but not necessarily so. The thing that attracted me in the Jason King decision that, raises concerns with regard to Springhill, the obvious issue is this reference to a lack of training, and Jason King certainly made reference to that in his testimony. But again, when you look at the way that Section 217.1 of the code is worded, it doesn't necessarily transmit liability to Springhill in the way that, some would hope that it does. I think that goes back to a comment you and I discussed earlier, which is the Occupational Health and Safety Act is broader in its scope. It gives the Crown a lot more flexibility to get to the desired outcome. Let's think about this. It seems to me that anyone who grieves the loss of Michael Henderson, and I think, we can all do that with sincerity, not to the extent of his loved ones, but when we think about that loss, that human loss, we know logically there's no way to really fix that. So now the question is, what can we do that will sufficiently demonstrate that the responsible person understands their responsibility and has taken this seriously and is going to make amends? I think there was a decision made that the plea arrangement made in mid-December of 2023 with Springhill achieved that objective. The alternative would have been to go to a trial. Perhaps the Crown would be successful. And if successful, perhaps the fine would be $100,000 again. Or maybe it would be $200,000. But maybe it would be $1 million. We don't know. But would that outcome warrant the risk of not achieving this conviction under the Occupational Health and Safety Act?
Okay, I had said a minute ago my last question, but look, it's just so great to have you on and to have someone that knowledge of the legal system. I have actually one more question. What is an appropriate deterrence? How do you determine that?
Yeah, this is what.
Case?
Yeah, you know what? I love that question, and I think this is not a question that even requires a law degree. This is a question of philosophy, right? It probably is subjective and objective, as I mentioned before. So what causes a person to say, look, I'm not going to make that mistake again, or I'm not going to make the mistake that I saw this other person make ever. Anyone who's a parent of more than one child has probably seen this. Like the second child, the younger child, sees the older child making mistakes and getting penalties, like being, grounded or whatever the penalty might be from the people who look after them. The second child often says, oh, that's a pretty serious penalty. I'm not going to make that mistake. I've done a fair amount of study in this, Pearlie, and I wonder, depending on the person who has made the mistake, isn't it sometimes the case that the deterrence is the grief and the remorse and the shame and the humiliation that they feel for having made this horrible mistake? Isn't that, in some cases, sufficient to result in no further mistake ever being made? In other cases, we know that the person who makes the error isn't going to be affected by shame or guilt or embarrassment or humiliation. And in those cases, we know that we need a more serious deterrence, right?
Look, Kelly, I'd like to thank you very much for joining us on our podcast today. Look, they're just really, if we had time, there's so many different areas we could delve into. Thank you very much again for joining us on today's podcast. We're going to have you in the future on another podcast dealing with another topic of interest, and that's respectful workplaces.
Yeah.
But for today, thank you very much. And we certainly appreciate you coming on and enlightening us on what and how the legal profession looks at a lot of these issues. If you would like to make comments on today's podcast, we'd love to hear from you. You can reach us at podcast@ssnb.ca. Stay safe. See you next week.